we're gonna have to go with that August date though. There's really no time.
Calling the matter of People versus Charles Taylor and Denise Kalapi. This is 210-5573902. Appearances, please.
Good morning, Your Honor. Abigail McIntyre appearing on behalf of the people, P71143.
Thank you.
And Judge Lyle Harris for Mr. Taylor. Good morning.
And good morning, Your Honor. May it please the court, Camilla Barkovic, P78254, appearing on behalf of Ms. Kalapi, who is present.
Ms. Kalapi, can you please state your name, please?
Janice Kalapi.
Thank you. And is Mr. Taylor at the jail? Is he zoomed in?
He is not zoomed in, and Judge, I'm not sure how the notice was even received yesterday since we were shut down, since we were closed.
Judge, I'm only to waive his presence just to set this date. I'll let him know.
Okay, his presence will be waived for purposes of today's proceeding. And we need to select a new date. I think we made a record yesterday, but we just need to solidify how we're going to proceed. What is your pleasure, Madam Prosecutor? Let me start with you.
Your Honor, I am just so the court is aware, I will be out of town August 5th through the 16th with an all-day exam on the 17th. Other than that, I can try to make anything else work, depending on the court schedule.
Judge, if I might, I prefer an afternoon date if we can get it. I note to the court that the co-defendant's out on bond and my client's incarcerated for something else. So just so the court knows that.
August 19th, I think.
I think we were toying around with August 19th at 1:30.
1:30.
At 1:30. Is that a date that was problematic or?
No, that's fine.
Your
for the
Honor,
people.
That's problematic for me. I do have a pre-existing scheduling conflict on that date. I did text both the prosecutor and Mr. Harris with my availability. I would prefer the 20th if that's available. I could do any time that day.
20th.
I could do that in the afternoon.
I could do the 20th in the afternoon as well.
Actually, I've got another exam with you at 11:30, Judge, so.
1:30, Judge.
Okay, August 20th at 1:30.
And Your
Okay,
Honor,
then.
I guess the question is would the court like a copy of the code or Ms. Kalapi's statement prior to that date, or?
Well,
We
it
just
depends. I think that's what another aspect of what we were going to discuss. I wasn't sure. I thought I was hearing Ms. Barkovic indicate she wants everyone to watch it in person. It's up to whatever. It would be quicker if I watched it in camera, and then we
That's
would come
fair,
back.
Judge.
Yes. Okay. Is that okay with Mr. Harris and Ms. Barkovic?
Well, I really
Yes,
have no
Judge.
dog. I have no dog in the fight. It's not my client's statement. It's co-defendant.
I'm asking.
And Your Honor,
thank you.
I'm sorry.
So if you could tender an MP4 format of the disc, that would be great, Ms. McIntyre, because if you send it via evidence link, it just doesn't work. I can't
Right.
watch it.
Your Honor, I will bring that to the court the beginning of the week. I will try to get it today. However, I am off tomorrow. So
No, that's fine. That's fine. If you can get it here, you said beginning of next week?
yes.
Okay, Ms. Barkovic, I'm sorry, what were you saying?
Okay. Yeah.
Oh, nothing, Your Honor. I just have no objection to the court watching it in chambers. I obviously made some arguments on the last court date as it relates to the validity of my client's waiver of Miranda and things along those lines. So I would object for the record to the admission of the statement, but if the court is going to admit it, then I have no problem with the court reviewing it in chambers.
Thank you, so noted. And I think we already, I don't have my notes from it. I think we already crossed that bridge, and that's why we were proceeding with the understanding that we were going to watch it yesterday. But if it hasn't yet been, has it been yet, Ms. McIntyre?
Your Honor, I believe that the court is correct, but the people would move for the admissions of co-defendant Denise Kalapi's statement, video recorded statement. I believe it's exhibit either 3 or 4 at this point.
I believe so. If that T has not been crossed, prior to going on the record when we come back. I will put that on the record. But Ms. Colby is here, I believe, right now. So with that being said, I'm fairly certain that that was placed on the record and over council's objection that was placed on the record before. I was going to proceed and allow the admission of that proposed exhibit. But if that was not said before, then I do want to make a record of that now, seeing as though I'm going to be watching it in camera.
Thank you.
Thank you. And that date for the adjourned exam day is August 20th at 1:30. We will see everyone on that date, in person,
That's correct.
Thank you, Judge.
Thank you. Have a good weekend.
Thank you, you too, for zooming in today.
Thanks.
I'm gonna call Mr. Nasser's case, Judge.
Okay.
Good morning, Your Honor. This is Division 1 checking, and we have Curtis Scott.
Thank you, sir.
Calling parties on Jones, case number 2157924. The people of the state of Michigan versus LaBrell Ray Jones Jr. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons, carrying concealed. Count 4, police officer, assaulting, resisting, obstructing. Count 5, 6, and 7, weapons, felony, firearm, habitual offender, fourth offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Brent Bailey on behalf of the people, P84009.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Mohammed Nasser, P74485, appearing on behalf of LaBrell Jones. Your Honor, Mr. Jones is not here. He is in the custody of the MDOC, so I'd ask to waive his appearance.
So ordered.
Your Honor, at this time, the people will be moving for dismissal.
Okay. Do I have a?
No, not in here.
Oh, okay. Well.
I can provide one to the court, Your Honor.
Oh, okay. And the basis for the?
The dismissal is based on the federal government is taking over the prosecution of this case.
Okay, and I would imagine there's no objection? And I would just need a form filled out. There are orders of dismissal blank forms. I need you to fill it out and to please add that language in the other category. And Mr. Nasser doesn't need to sign, but I do need your signature on that. And we will give a copy to Mr. Nasser if he wants to wait. Otherwise, we can email it to him.
I'll wait, Judge. Thank you so much.
Thank you.
Thank you.
Always a pleasure seeing you, Judge.
Likewise. Have a good and safe day with that weather out there.
Do I have the parties on Scott, Curtis Scott?
Hi, yes, you do. Well, Shabazz is here.
Okay.
Thank you so much.
That's Mr. Bloomers. Mr. Bloomers?
Yeah, I'm here.
Two cases. Do you have both cases or does General have one and you have the other?
I believe I just have the one.
Yes, Mr. Bloomers has one and I have the other.
Okay. Calling parties on Scott, case number 2157107. The people of the state of Michigan versus Curtis Scott. The defendant is charged with count 1, home invasion, first degree. Count 2, assault with a dangerous weapon, felonious assault. Count 3, assault with a dangerous weapon, felonious assault. Habitual offender, third offense notice. The defendant is also charged in case number 1957815. The people of the state of Michigan versus Curtis Scott. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, home invasion, second degree. Count 4, domestic violence aggravated. Habitual offender, third offense notice. These matters are scheduled for a competency hearing.
Thank you. Appearances, please.
Morning, Your Honor. Jacob Bloomers, P77307, appearing on the case ending 7815.
Morning.
Good morning, Your Honor. Brent Bailey on behalf of the people appearing in case 7107.
Good morning, Judge, to you and your staff. May it please this honorable court. Justina Shabazz, P number 82743, appearing on behalf of Mr. Curtis Scott, who is also present by way of Zoom in the Wayne County Jail Division.
Okay, please state your name. Please state your name.
Mr. Scott.
How you doing today, Your Honor? My name is Merle Scott Jr. I'll just, state my name for the record.
Thank you. Thank you. So with regards to these two matters, do we have a report back from the forensic?
I have not, the court hasn't received anything, Judge.
And neither has defense.
Excuse me, I already been to the forensic center. They told me I ain't got nothing to worry about. They let me go.
Mr. Scott, you wanna mute yourself really quick. The judge is speaking. I'm gonna speak on your behalf.
Okay, so I just wanted to know if either the prosecution or defense has a copy of an evaluation that has been returned. If not, it sounds like we need to adjourn this for that report to be generated and provided.
Judge, I have not received the report.
Has your interviewed? Has your client been interviewed?
It sounds as though he was. I attempted to speak with Mr. Scott during a jail visit once before. I was not successful, but based off of what he just stated right now, it sounds as though he was interviewed by the forensic center. However, I still do not have a report and I haven't heard anything from that. If you would give me a moment in the breakout room, I can confirm that very quickly.
So you have no idea, you haven't had any contact with the forensic center to the extent that you know what the delay is attributed to and what sort of time frame? Because otherwise I'm just going to generically give you like 30 days.
I have not had any communication. Normally I would receive the report by mail to my office. I did check with my office. There was no report there. My mail is being forwarded from my office. I also did check on my home address. I do not have the report. And I was expecting it based off of the last court date that we had. I was expecting it at least by the end of June.
Okay, I was going to put you in a breakout room, but you know, we're having a little bit of technical difficulties with the storm, with the power and whatnot. I can't really do anything with Zoom. It's not letting me, hold, it might let me do it now, hold on. So I'll put you in a breakout room, perhaps you can have get an idea as to whether or not there has been an interview and let us know. Again, I'm looking at adjourning this for 30 days so that we have an opportunity to see what's going on and can get a report back. So I'm going to put you in a breakout room right now.
Okay.
Here, another case. Yeah.
Calling parties on Diebold, case number 2159082. The people of the state of Michigan versus Tyrone Diebold. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, arson, preparation to burn real property. Count 3, malicious destruction of building, $1,000 or more but less than $20,000. Count 4, larceny in a building. Count 5, malicious destruction of personal property, less than $200. Count 6, domestic violence, habitual offenders, second offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. May it please the court. Kim Michon, Neighborhood Defender Services, on behalf of the defendant. Your Honor, he is not on the call. We would waive his appearance for these purposes.
So ordered, and good morning to you. What is your pleasure here today?
Your Honor, we need discovery in the matter, and we would be requesting an in-person preliminary examination.
Okay. Mr. Bloomers, are there any concerns regarding the bond that would affect the setting of the exam date, the timing of it?
Your Honor, no concerns at this time from the people. The people are satisfied.
Okay, so maybe, I think late September.
Yeah, I'm checking. September 14th at 11:30.
That's fine for defense.
Okay, the live exam, in-person exam, September 14th at 11:30 in the morning. Please make sure that your client understands that he's to appear in person, not on Zoom, and that he should abide by the provisions that were put into play on the date that he was arraigned, particularly that there be no contact with the complaining witness. The prosecutor has indicated that he's satisfied with the bond as it is, so that I'm assuming that means there's been no issues since he was arraigned, and that's a good thing. Is there anything further?
No, Your Honor. Thank you so very much.
Thank you.
A lovely day to you and your staff.
Judge.
You too. Calling parties on Harris Perry, case number 2158937. The people of the state of Michigan versus James Dwayne Harris Perry. The defendant is charged with count 1, police officer assaulting, resisting, obstructing. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Neighborhood Defender Service by Natalie Phelps, P number 83355. I would move for Shannon Halp to be to practice pursuant to MCR 8.120 for today's hearing. She's a third-year law student in good standing at the City University of New York School of Law, appearing under my supervision.
Granted. Did you want to put your name on the record?
Yes, thank you, Your Honor. Good morning. Neighborhood Defender Service by Shannon Haupt, practicing under the supervision of Natalie Phelps, P number 83355, appearing on behalf of Mr. James Harris Perry, who is present via Zoom. Mr. Perry, can you please state your name for the record?
James Harris Perry.
Thank you. Counsel, what's your pleasure? Do you have discovery? And if so, did you want to set this for an exam or another PCC?
Yes, Your Honor, we have full discovery and we'd like to set this matter for an in-person preliminary exam. Mr. Harris Perry has a separate case scheduled for exam on December 9th, and we're wondering if Your Honor would be willing to schedule it for the same date.
Yes, that makes sense. What time is it set for on December 9th?
10 a.m.
We'll set this for 10:30 then.
Thank you, Your Honor.
So, Mr. Harris Perry?
Yeah.
Make sure that you plan to be in the courthouse, not on Zoom. In the courthouse. Sounds like you've got another matter as well. The time for the first matter, obviously your attorney just indicated, is 10 o'clock. And this instant case that was just called will be set for 10:30 to follow right after.
Okay.
Any concerns from prosecution or defense regarding bond or otherwise?
No, Your Honor, people don't have any concerns at this time.
Madam Defense?
Defense has no concerns at this time.
Thank you. We're all set December 9th at 10:30 for live in-person exam.
Thank you, Your Honor. Have a great day.
Thank you, Your Honor.
You're welcome.
Calling parties on Syed, case number 2158780. The people of the state of Michigan versus Muammar Syed. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, domestic violence, habitual offender, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Ms. Murphy? Calling parties on Sanders. Case number 2062188. The people of the state of Michigan versus Andre Martez Sanders. The defendant is charged with count 1, controlled substance, cocaine, heroin, or another narcotic less than 25 grams. Count 2 and 3, weapons, felony, firearm. Count 4, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 5 and 6, weapons, felony, firearm. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. John KCP number 56162, appearing on behalf of the people.
Good morning, Your Honor, and good morning to your staff. Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. Andre Sanders.
Okay, and is your client present?
Yes, he's present. Mr. Sanders, can you state your name for the record, please?
Yes, Andre Sanders.
Thank you and good morning. Okay, so we're here today for, looks like an examination. Was it a Zoom exam?
Your Honor, we believe that we have worked out a deal with the prosecutor, but in order for us to consummate the deal, this matter has to be sent over to Third Circuit Court. So today we're just going to waive the preliminary examination.
Okay, I see. Is there, I'm assuming there's no objection with that representation having been made?
No, Your Honor, correct.
Thank you. So, Mr. Sanders, I just need to ask you a few questions. Do you understand the allegations against you, sir?
Yes.
Do you understand that you do have a right to a preliminary examination?
Yes.
Do you understand that if an examination did occur, that the prosecutor would have to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that?
Yes.
And the representation made here by your attorney is that you wish to waive, to give up your right to preliminary examination. And do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination?
Yes.
And is that what you wish to do?
Yes.
And are you doing so voluntarily on your own?
Yes.
Thank you. And I do have the examination waiver form returned to the file. Appears to be properly executed. Thank you for that.
Yes, I'm here. Just stay in there and be in the waiting room. So.
The matter is going to be bound over to the circuit court for further proceedings with an AOI date of July 29th. Is that right?
Yes, that's right.
At 9 a.m. Mr. Casey, was there anything further?
Nothing on behalf of the people, no.
And nothing further to finish, Your Honor.
Okay, we're all set. Thank you so much. You can log off now, Mr. Sanders.
All right, thank you. Have a good day.
You too.
Have a good day, all.
All right.
You too.
Judge, I'm also back for Curtis Scott. Before we go on the record, Judge, I also do want to indicate, we can put on the record as well, but I will have to withdraw from the case.
Oh. Okay. Can we call her? We're going to call it in just a moment, okay?
Okay, I can do that to you. Is it Zoom? I'm gonna need to put you on hold, okay? Just a moment.
Not trouble you to call.
I'm doing it right now.
So we can do it all in one stop.
Commissioner Biles was also on this exam case that she told me it was gonna be dismissal, so I'm going to call that. It's scheduled for 9:30.
Okay.
Hello?
Okay, calling people versus Marvin Green, 21057H22. The defendant is charged with count 1, robbery armed. Defendant is listed as an habitual offender, third offense notice. Today is the date and time set for an examination. It was set for 9:30 this morning. Can I have appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning.
Good morning, again, Judge, to you and your staff. Distinguished Shabazz, appearing on behalf of Mr. Marvin Green, who is also present by way of Zoom.
And could you please state your name, Mr. Green?
You have to unmute.
Marvin Green.
Thank you. Okay, today being the date and time set for an examination, are we proceeding to an exam?
No, Your Honor, we are not proceeding to exam today. The people were in contact with the complaining witness in this matter, Your Honor, and we're making arrangements to provide for his travel and lodging in order to testify here at court today. And prior to those plans being concretely solidified, the complaining witness ceased all contact with the prosecutor's office. And as such, has not made it to the state of Michigan for today's exam, since we are unprepared.
Okay, is there a motion?
Yes, Judge, we move to dismiss.
Okay, it is currently 9:37 by my watch. Again, this matter was set for 9:30 this morning. And with the representations that have been made, I am going to grant that motion for a dismissal. Mr. Green, I'm dismissing this, however, without prejudice. And what that means, Mr. Green, that language that follows the word dismissal, that means that it is possible for the prosecution to reissue on this matter. Now, if that's confusing, or if you're not sure what that means or the parameters of that, please make sure that you're in contact with Ms. Shabazz and she will explain it to you in greater detail. But I also want to ask Mr. Green, do you have on a GPS tether that needs to be removed?
Yes, I do have.
And that was placed as a result of this case?
This will be your first.
Yes, ma'am.
Okay, that GPS tether shall be removed forthwith. I'm going to add that language onto the order of dismissal. And we will also alert the tether unit from our angle here, but it's a good idea for you to have that copy with you if Ms. Shabazz can get that to you somehow in the event that there's any confusion regarding removal of that tether. Ms.
Okay, what about my
Shabazz,
vehicle?
Ms. Shabazz, do I have permission to sign your name to the order of dismissal as the moving party? Ms. Shabazz?
Yes.
And Ms. Shabazz, I do apologize. What is your first name?
Justina, Justina.
What about my vehicle?
Mr. Green, I'll speak on your behalf. Give me 1 second.
Thank you.
Okay, I am preparing that order right now. Was there something else?
Yes, Judge, with regard to the dismissal, Mr. Green's vehicle, well, his mother's vehicle, it was also seized, as well as his cell phone. With the dismissal being granted, Mr. Green wishes to also have that property. Will that language and the dismissal be sufficient to have his property returned?
Not necessarily, unless the prosecution indicates same. I don't know if there's some reason that the police authorities may be doing any further investigation with that, so I cannot unilaterally just add that language on. Madam Prosecutor?
Your Honor, I have heard no information as to whether or not the police department intends on maintaining control of those items. Certainly, the dismissal of this case would cease the necessity of it for this case, but I don't know if there are any further ongoing investigations. I would advise Ms. Shabazz and Mr. Green to reach out to the officer in charge of this case and speak with him, and he will be able to ascertain better than myself whether or not Mr. Green will be able to gain control of this property.
Okay, so Ms. Shabazz, if you could do that, reach out to the officer in charge, and if for some reason the information hasn't channeled its way to that officer in charge, if you could let him know the matter has been dismissed and that you have a copy of that dismissal. And if there's any issue beyond that, then if you could communicate with Ms. Bailey or Ms. Yafufi, one of the general warrants prosecutors, so that they can get to the bottom of it, because again, I do not know. I cannot just unilaterally sign an order if I have no assurance that it is no longer needed by the authorities. I'm assuming it's not because of the dismissal, but the dismissal is because a complaining witness failed to appear. So I just certainly don't want to just blanketly say, return the vehicle, and there may be some ongoing investigation. So if there is an issue that arises as it relates to this, and you need to motion it up back before the court, please do so. But my first suggestion would be to contact the officer in charge And if there's a wrinkle with that, please let the prosecution know.
Thank you. And Judge, will that dismissal be sent to my email address? Do you already have it?
I'll email it.
Yes, Madam Clerk will send it to you.
Thank you.
It's in the prosecutor's office already, the vehicle.
Mr. Green, I'll contact you.
All right.
Okay, we're all set. Thank you.
Thank you. Mr. Green, you may log off. I'll give you a call when I'm done with work.
All right, thank you.
I'm gonna apologize now if I get cranky. I like hot weather, but I like hot weather at the beach and at the pool, not at work.
It is so hot in here. You're humid.
All right. Calling parties on King, case number 2158370. The people of the state of Michigan versus Kevin King. The defendant is charged with count 1, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. Habitual offender, fourth offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. James Anderson, P31302 on behalf of Mr. King.
Okay, Mr. King.
The last I spoke with Mr. King, he was in the waiting room.
I don't think I have a waiting room yet. I haven't enabled a waiting room. So, Mr. King, are you here? You have anything else to call?
I do. I'm ready to call yours. Calling parties on Esom. Case number 2061298. The people of the state of Michigan versus Tony Reynard Esom. The defendant is charged with count 1, license documents, plates forgery. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slosky on behalf of the people, P83677.
And good morning, Judge. May I please report Jeanette Nancy, 68686. Eason, who is not here. Judge, going on, I have been in contact with Eason. I am not today, but I can't explain his whereabouts today, but as soon as I reach him, I will be having him come back and report.
Okay. Have we received a phone call from Tony Esom?
No, no calls.
And perhaps by mistake, is there a Tony Esom on Zoom gallery as opposed to being here in person? Tony Esom, E-S-O-M? Hearing no response, is there a motion?
There is, Your Honor. At this time, the people move the court to issue a case.
Okay. Okay, it is currently 9:43, and this matter was set for an exam at 9:30, and the defendant has failed to appear, failed to call, and failed to appear on Zoom. So with that being said, I am going to grant that motion for capias. A capias will issue. Previous bond is going to be forfeited. New bond is going to be set at $5,000 cash or surety. And in the event that you're able to get his presence, really anytime before, say, 3 o'clock, you can just Zoom back in and we'll get this on track. Out of curiosity, did you have any witnesses?
Yes, Your Honor, my witnesses are available. I also had a plea offer available if Mr. Esom does available. So just let me, anytime today, we'll keep the plea open. I'm sure if he comes up later, I'm not gonna, pull the rug out, but, just let me know and we'll do it.
Absolutely, Judge, we had definitely been working because I had been speaking with my client, so I'm not sure what's going on.
All right, and sometimes there are emergencies or confusion about what to do, where to go. But I will say if it's after today though, after Madam Clerk enters that, which is usually around 3, then he will have to, the capias will be entered and he will have to avail himself as anyone typically would when there's a capias that's been issued. So with that being said, I thank you for coming in today and stay cool. It's burning up in here.
It is very
Oh my
humid.
God.
Thank you, Judge, and everyone have a great day.
You too.
Judge, can we?
Your Honor, I'm
Yes.
checking in on Charles Kelly from Division 2. I see maybe he's just coming on the screen. Okay.
And Judge.
This is Mr. Kelly.
is now
Okay.
present. He's 1+ Nord in 100.
What did he say?
Information overload, I'm not sure.
What did you say, sir?
On Kevin King, he is now present. He is
Oh,
it is 1+ Nord.
thank you so much. I'm gonna recall that right now.
And Judge, one other thing for her to Scott, I'm still here. We didn't conclude that matter. I didn't want for them to send him back. He's in the Wayne County Jail.
Yeah. I have a court appointed.
I called to get a new attorney appointed, so as soon as they zoom in, we'll go back to him.
Okay, will I be able to withdraw? Do I have to wait before another one is appointed before I can withdraw off the case?
Well, typically, this is a really, really quick process. So I'm expecting any second now, someone to zoom in. And yes, I would like for you to wait because we do need to make a record and I haven't quite even heard what the basis is for the withdrawal, but I'm assuming that you'll be able to put forward what, I think I handed this to you already, let me hand that to you. So in anticipation of you being able to, represent what it is that causes you to withdraw, I just want to have that court appointed teed up. So if you could give us just a couple more minutes.
Okay, and Judge, I'll also call the court because part of it is personal. The prosecutor already knows and she's aware. So I'll call the court so that I don't have to put everything on the record as well, so that you're also aware. I will place what limited information I can place on the record. I will put that on the record.
Okay, thank you.
Thank you.
Recalling versus Kevin King. This is 2105867 and this is a recall. It was already formally called. Can I have appearances again, please?
Yes, Your Honor. Good morning. Bryn Bailey on behalf of the people, P84009.
Good morning, James Anderson, P31302 on behalf of Kevin King, who is present via Zoom. Mr. King, please state your name.
Kevin D. King.
Thank you. So it's my understanding that your client is going to waive his right to an exam. Is that true?
Yes, Your Honor. I have reviewed the exam waiver document with him. He gave me permission to sign his name. I've explained to him that he had the right to hire his own lawyer and that he also had the right to have a preliminary examination in which the prosecution would have to show probable cause to believe he committed the offense that he's charged with and that it happened in the city of Detroit. I believe he understands his rights and wants to waive this morning.
Okay. Is there any objection to the proposed waiver?
No, Your Honor.
With that being said, Mr. King, do you
Yes,
understand? Do you understand the allegations against you, sir?
Yes, I do, Your Honor.
You understand that you do have a right to a preliminary examination?
Yes, I do, Your Honor.
Do you understand that if an examination did occur, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes? Do you understand that?
Yes, Your Honor.
If the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process, sir?
Yes, Your Honor.
So the representation has been made that you wish to waive your right, give up your right to an examination. Do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an exam?
Yes, Your Honor.
And again, is that what you wish to do, sir?
Yes, Your Honor.
Thank you. And are you doing this voluntarily, sir, on your own?
Yes, Your Honor. Here I am.
I have received the examination waiver form back. Thank you, Mr. Anderson, and it is purportedly executed sufficiently here, so I am going to add my signature to it. The matter is now bound over to the circuit court for further proceedings with an arraignment on information date of July 29th at 9 a.m. Is there anything further from the defense or prosecution?
Nothing further for the people.
Nothing further. Thank you, Judge.
Thank you, sir. You can log off now, Mr. King.
Thank you, Your Honor.
Have a great day, staff. And you.
Thank you, Mr. Anderson.
Take care. I mean, did they say when the error is gonna?
You know what, the email that they sent a little, like an hour ago said that they should have it back. RCG hearings, I think that's Mr. Nasser's defendant.
Which one again?
Our RGC backup hearings, what's your name, sir?
Gabriel Jones.
Yeah, that's the one we already dismissed, Judge.
Oh, Mr. Nasser?
Mr. Nasser's
Okay,
case.
your case has been dismissed, sir. We called it and your attorney was here. He asked for your presence to be waived, and the prosecution dismissed your matter because the feds have picked your case up.
Okay.
Okay, so your attorney, I would assume, will be in contact with you, but there's nothing left to put on the record. You're all set. Case has been dismissed without. Division 2, floor 7. What's your name, sir?
Hey, good morning. This is Mr. Kelly, Harold Collins' client.
Okay, let me find it, Judge.
Isam, are you here?
Yes.
Mr. Slusky, this is your case, right? That's what you're on.
Judge, can we advise him to call me?
Before we go on the record?
Yes.
Okay. Mr. Isam,
Yes.
I need you to call your attorney. You have her number, correct?
The lawyer, right?
Yes.
She never answered from me. I've been trying to call her and let her know that to make sure the court date and stuff was. I've been leaving her message, but she never answered the phone.
She's here in the courtroom right now, but she's going to step in the hallway because she wants to talk to you before we call the case, okay? Do you want to give your number to make sure?
Yes, Mr. Eason, my number is 313-277.
Hold on, one second. You said
313.
Yes.
277.
Yes.
9777.
Yeah. Okay, I'm about to call.
Okay,
thank you.
Okay.
Calling parties on Kelly, case number 2158941. The people of the state of Michigan versus Charles Kelly. The defendant is charged with count 1, robbery armed, count 2, robbery unarmed, count 3, weapons, firearms, possession by felon, count 4, weapons carrying concealed, count 5 and 6, weapons, felony, firearm, habitual offender, court offense notice. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Morning, Your Honor. Elizabeth Zornick appearing on behalf of the people, P79420.
Good morning.
And good morning, Your Honor. Harold Collins, P56805, on behalf of Mr. Charles Kelly, who is present on the Zoom screen. State your name for the record, sir.
Charles DeJuan Kelly.
Thank you. Good morning to you both. Today is the date and time set for PCC. I'm assuming, Mr. Collins, that you have discovery now?
Pardon?
Your Honor, I have received the digital discovery. However, it is in a format that is unusable for me at this time. I talked to Ms. Dornick about that. She's going to have it redistributed to me so that I may view the surveillance videos that are in the discovery package.
Okay, so with that being said, I recognize that this is our second PCC. Did you want to put this down for an exam?
We can set that date, Your Honor.
Okay, so once Madam Clerk is off the phone, I'm going to ask her to look for a date the week of July 26th. How many proposed witnesses do you anticipate?
Your Honor, there'll be at least two. There might be a third witness.
Okay.
Okay.
This is an in custody. Can we find a place to squeeze this in on the week of July 26th?
And Mr. Kelly, I have sent you paper discovery, so you should have that over the next day or so.
Okay.
All right.
Judge, July 26th at 10 a.m.
How does that date work? July 26th at 10 a.m.?
That's doable, Your Honor, for the defense.
Fine.
Okay, in-person exam, July 26th, 10 a.m. Is there anything further?
I just want to place on the record that Mr. Collins did ask me for those, I guess, converted videos this morning. I've already requested them and they've already sent me back an indication that they are working on them. So he should probably have them tomorrow.
Oh, great. Thank you for that.
And I'll be visiting you, Mr. Kelly, over the next week or so.
Anything further?
No, Your Honor.
No, thank you.
Thank you.
Okay. Do I have the parties on Guzman and Santillan?
Yes, Attorney Mitchell first and Talano. I'm not sure how to pronounce his last name. He's on as well.
This is Sharon Woodside. I'm ready on Mr. Guzman. Mr. Guzman is present on Zoom.
Okay. Calling parties on Santillan and Guzman, case number 215894. The people of the state of Michigan versus defendant number 1, Daniel William Guzman. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 3, weapons, felony firearm. Habitual offender, fourth offense notice. Defendant number 2, Jacob Marco Santillana, is charged with count 2, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 4, weapons, felony firearm. This matter is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Morning, Your Honor. May it please the Honorable Court, Sharon Clark Woodside, appearing on behalf of Mr. Guzman. Mr. Guzman, can you turn your video on, please?
And good morning, may it please this most honorable court. Rena Mitchell appearing on behalf of the second defendant, Jacob Santillano. Could you please state your name for the record?
Jacob Marco Santillana.
Okay, I didn't hear Mr. Guzman say his name.
Mr. Guzman, can you turn your video on, please, sir?
It is on. I don't know why it's not working.
I need you to state your name and try your best to get your video working. If you stated it, we didn't hear you. Please state it again.
Daniel Guzman. Daniel Guzman.
Okay. Apparently his video is not functioning. What is your pleasure, Ms. Woodside and Ms. Mitchell?
I'm asking for a preliminary examination and for the people to produce any and all digital discovery.
Your Honor, I agree and that I would like the same for my client.
Okay, you have for discovery?
I have paper, but no digital.
Okay.
Your Honor, the digital discovery has been requested. And I did call Ms. Mitchell yesterday and left a message with her office, as I do not have an email address to share what I currently have with her.
Okay, I'll put my email in the chat for you now.
I'm unfortunately not on Zoom. so I will not be able to see the chat.
Can you just give us your email right now?
It's a private clause. I thought. Yeah, it's not. It's a private conference.
Okay, so I'm going to assume she's going to get that to you at some point. Ms. Mitchell, we need to set an in-person examination
Yes.
date. Both defendants are not in custody. So I think we're probably looking November, December.
Okay, Judge.
Can you give your, while Madam Clerk is getting a date, can you give your email address to Madam Prosecutor?
Are you ready? It's my first name, Rina, RINNA 527 at yahoo.com.
527 at Yahoo?
Yes.
Thank you, ma'am.
My first name, 527 at yahoo.com.
Thank you. I will get you the paper momentarily.
Okay, thank you.
November 4th at 10:30.
November 4th at 10:30. Does that date work?
That works for me, Your Honor.
Ms. Woodside?
By any chance, do you have an afternoon time, Judge, by any chance? The 4th, wait a minute, am I starting that trial? Sorry, I'm talking to myself, sorry. If Ms. Mitchell can do an afternoon.
Are you available the afternoon of November 4th, Ms. Mitchell?
Yes, I am, Your Honor.
Okay, so November 4th at 1:30, not 10:30, 1:30.
Okay.
For this examination. And so the expectation, I'm speaking to the defendants here, is that you will be here in the courthouse, not on Zoom, in the courthouse and in this courtroom for your in-person examination date. Please make sure that you plan to arrive early in advance of that 1:30 time so that you can pass through the appropriate security channels and health screening and make your way into the building without any delay, okay?
Your Honor, I need one thing. Can you place me in a breakout room with my client?
Yes, you are, let me see, did he get his video? Which phone is he?
He has video. It was, my client is Jacob, Your Honor.
I see, but I'm just trying to figure out where his device is. Is he, oh, okay, I think I see it.
Yeah.
Hit join when you see it across the screen, Jacob.
Okay, ma'am.
Mr. DiMaggio, what case are you checking in on?
Thank you, Your Honor. I'll be in touch, Mr. Guzman.
Okay, take care. Have a good day.
You too.
Morning, Tammy. I was told a spot assignment for Mr. Scott.
Yes, thank you so much.
Right.
Recalling, wait, hold on one moment. Recalling People versus Curtis Scott. This is 2105710. 07 and 190578115. These matters have already been formally called. Can I have appearances, please?
Jacob Bloomers on behalf of the people on the case ending 7815.
And Rick Bailey on behalf of the people for case ending in 7107 P84009.
Good morning again, Judge, to you and your staff. Justina Shabazz, appearing on behalf of Mr. Scott.
Okay, so just to get you up to speed, Mr. DiMaggio, could you put your appearance on and I'm going to give you some background.
Okay, Andrew DiMaggio, P45619 on behalf of Mr. Scott.
Okay, so where we were when we called this case earlier, Mr. DiMaggio, today is a competency review. And unfortunately, there is no competency evaluation that has been returned to the file. And the court is not in receipt of it, nor is defense or the prosecution on either file. I think we paused at the point where I was wondering whether or not the defendant had been interviewed at all to give us a sense of at least how far out we need to adjourn this. And I'm remiss in putting Mr. Scott's name on the record. Could you state your name, sir?
Scott Jr., but excuse me, ma'am, can I say something?
Wait, no. Hold on one second. You will have an opportunity, but I'm trying to just lay a foundation here. So we had allowed Ms. Shabazz an opportunity to go into a breakout room with her client because she was going to make some inquiries specifically with regards to whether or not he's even had the interview. So we have a sense of how far out we need to adjourn this to receive an evaluation back. That is where we paused in this matter, and Ms. Shabazz had indicated she wanted to make a record after having come out of the breakout room. Ms. Shabazz?
Yes, thank you, Judge. I did speak with Mr. Scott, and I also was able to ascertain from the deputy that Mr. Scott was interviewed this past Tuesday. So I believe that the report, it will take some time because he was just interviewed earlier this week.
And who are that interviewed by?
And that actually came from the deputy. He just verified that he was interviewed. Mr. Scott has indicated that he has not been interviewed, but the report will verify everything that will go along with both cases in due time. Additionally, Judge.
Go ahead.
Thank you. Additionally, Judge, I did speak with Mr. Scott and I did inform him that unfortunately I will have to withdraw from the case. This case, the first case that I was on has been going on since 2018. So I do have a long history with Mr. Scott, and I am sad to even have to withdraw. It's nothing that Mr. Scott has done. I want to make sure that is conveyed to him because I don't want for him to think that he has done anything wrong to get me to withdraw. I actually need to withdraw for personal reasons due to my health. This is one of many cases that I will be withdrawing from. I was hoping that I could stay on the case given that it will be drawn out with the competency hearing and another review, et cetera. However, I do not know how long I will need for my own personal health and with Mr. Scott being in custody, I believe that he will want to have a speedy examination and a speedy trial, et cetera, which right now I am not able to give him. I would have to request numerous adjournments possibly, and I don't want to do that to him. So that is why I am withdrawing from many of my cases, including this one.
Motion to dismiss.
Okay, Mr. Scott, can you hold for just
Yes,
one?
ma'am. Yes, ma'am. I apologize.
Okay, so Ms. Shabazz, I just want to, before we pivot here, I just want to make sure, have you communicated, at least when you were in the breakout room, to Mr. Scott that you would be withdrawing?
I have, yes. And it's hard for him to accept, but I did explain why I need to withdraw. It's due to my own personal health. And I also already expressed that to the court as well.
Okay, and I do understand that. Mr. Shabazz, given the representations that Madam Defense, Ms. Shabazz has laid out on the record here, I am satisfied with her withdrawal as the basis for which she's indicated is for health reasons. Certainly, I'm not going to force her to proceed in this matter with what she has stated on the record. And in the interim, what has happened is that Madam Clerk has called for a new court-appointed attorney, and that attorney is present, Mr. DiMaggio. So what I'd like to do is to place Mr. DiMaggio and Mr. Scott into a breakout room so that Mr. DiMaggio can introduce himself and answer any questions that preliminarily that Mr. Scott might have. Mr. DiMaggio, can I do that?
Yes, Your Honor.
Okay, hold on, Mr. Scott.
Yes, she's here.
And thank you, Judge. I'm actually going to log off now.
Thank you. Yes, you are released from the case. Thank you so much, and good luck to you.
Where's the? Yeah, I think that's, yeah, have him come and I'll call your case again. Calling parties on Simmons. Case number 2158934, the people of the state of Michigan versus Deborah Simmons. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. This matter is scheduled for probable cause conference, but I believe we need Mr. Slusky on that one too.
Oh, okay.
So, hold on. Do I have the parties on Syed, Miss Murphy?
Yes, I'm here.
Mr.
People are ready.
Bloomers?
Yep, I'm here.
All right. Recalling Syed, case number 2158780. This case was previously called in full, is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Judge Francis Murphy for Mr. Syed.
And your client?
He is not here and I have not been able to get a hold of him. I don't believe I have any contact information for him. I don't know if your clerk has any contact information for him.
We would not have anything that you don't have that was provided to you in discovery. Mr. Bloom have some more updated information, but the court does not. Today is a PCC, correct?
That is correct.
And this is the first PCC?
It is. I do have a phone number for him. I haven't been able to get through to him, or I haven't received any responses. This is the first PCC.
He is on Tether, so you may be able to contact the Tether unit and get some updated info, but I wouldn't have anything other than what's in the discovery.
Are you requesting to waive his presence for purposes of this first PCC?
Yes, Judge.
So ordered. And I'm assuming based on the representations, you'd like a second PCC?
That is a great idea. That would be great. Thank you, Judge.
Okay, what about August 5th? August 5th at 8:30?
Yes, at 8:30, that works.
Okay, we'll see you then. Hopefully that will give you an opportunity to establish contact with your client. And yes, if he is on Tether, then that would probably be a good starting point, contacting the Tether unit.
Will do. Thank you, Judge.
You're welcome.
Thank you, Judge.
Thank you.
Recalling Esom, case number 2061298. People of the state of Michigan versus Tony Raynard Esom. This case was previously called in full, is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
And good morning, Judge. May it please the court, Janeki Nancy, 68686, appearing on behalf of Mr. Esom. Judge, Mr. Esom is not present in the court. However, he has appeared virtually via Zoom. Mr. Esom, would you please state your name for record?
Look,
Mr. Esom, say your name, please.
Tony East.
Thank you. Judge, previously the court had issued a case. I would ask the court to set aside the case if a warrant was issued, recall the warrant as Mr. Esom. It was my understanding, I received a text about 5 minutes after I walked out of the courthouse that he had zoomed into the court.
Okay. Mr. Bloomers?
Yes, Judge.
On that last case, did you have any concerns on bond? Because if so, I'd like to call the attorney back.
No, he's on Tether with house arrest and hours for work, so I'm satisfied.
Okay, thank you. Okay, back on people versus Esom. What is your pleasure here today?
Judge, after having an opportunity to speak with.
Oh, wait, first, I'm sorry, if I could just indicate that what was placed on the record earlier was a caveus that was granted. That caveus is now set aside as the defendant, although he's not present in the courthouse, which is where he's supposed to be, he has made a good faith effort here and has appeared on Zoom. So I certainly am comfortable proceeding in this vein with him on Zoom if counsel is.
Yes, Judge, I am.
Okay. And does the prosecutor have any objection?
No, Your Honor.
Thank you.
Thank you. Judge, after speaking with Mr. Slusky as well as speaking with my client, today is the date and time set for preliminary examination. After speaking with Mr. Eason, he has advised me at this time he would like to waive his right to preliminary examination. We do need to sign the waiver, and I would be signing on his behalf that he wanted to waive the preliminary examination. Is that correct, Mr. Eason?
Yes.
Is there any objection from the prosecution?
No, Your Honor.
Okay, Mr. Eason, I just need to ask you some questions, okay?
Yes.
Do you understand the allegations against you, sir?
Yes.
You understand that you have a right to a preliminary examination?
Yes.
Do you understand that if an examination did occur, that the prosecutor to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed that crime? Do you understand that?
Yes.
And if the prosecution was able to clear that hurdle, the matter would then be bound over after the examination. Do you understand that?
Yes.
So the representation has been made here just now that you want to waive, to give up your right to a preliminary examination. Is that true, sir?
Yes.
Do you understand that that means this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination?
Yes.
And is that how you wish to proceed, sir?
Yes.
Thank you. Are you doing so voluntarily?
Yes.
Thank you. So we will hand an examination waiver form to Madam Defense, who is, I believe, has received permission from you, Mr. Eason, to sign this form on your behalf.
Yes.
The matter is now bound over to the circuit court for further proceedings with an AOI date of July 29th.
I'm sorry, Judge, we are going to tender a plea.
Oh, I'm sorry?
We're going to tender a plea today.
Your Honor,
Wait, I'm confused.
I apologize. I should have spoke up. I didn't want to interrupt though. We're pleading this to a misdemeanor of unlawful use of a license plate.
Okay.
I emailed it to you, Jen.
Well, certainly, it probably would have been appropriate for you to interrupt.
Sorry, Judge.
My mistake.
Okay. Thank you. Would you like to lay out the plea offer on the record?
Yes, Your Honor. Mr. Eason is charged with license plate forgery, which is a felony. The plea offer is to reduce that one count to unlawful use of a license plate, MCL 257.256, which is a 90-day misdemeanor. The sentence is to be determined by the sentencing judge. Additionally, diversion or delayed sentencing is not available.
Is that your understanding of the negotiation?
Yes, Judge, and I did express that to Mr. Eason. And my understanding from Mr. Eason is he would like to accept the offer that has been presented by the state, and we have reviewed his rights as well, Judge.
What was the last part?
And we haven't reviewed his rights that are included on the plea form. We did review those as well.
Okay, Mr. Eason, do you understand the negotiation? The negotiation is that your felony would be reduced to a misdemeanor.
Yes.
And disregard everything I just said about this matter being bound over. It was my understanding, I thought you were waiving your exam and going to circuit, but the negotiation is that you would have your felony reduced to a misdemeanor and that you would be tendering a plea to that reduced misdemeanor today. Is that your understanding, sir?
Yes.
You understand that you have a right to an attorney, sir?
Yes.
You understand that if you couldn't afford an attorney, one would be appointed to you, sir?
Yes.
You understand the allegations against you, sir?
Yes.
Do you understand that you have a right to a trial?
Yes.
You understand that if a trial occurred, that the prosecutor would need to establish, but beyond a reasonable doubt, what they are alleging that you've done. You understand that?
Yes.
Do you understand that if a trial did occur, that you would be able, and your attorney, to cross-examine witnesses and even have your own witnesses subpoenaed? And in beyond that, you could even testify on your own behalf if you wanted to. Do you understand that?
Yes.
Do you understand that if you tender a plea of guilty and the court accepts that plea, that has the effect of giving up your right to a trial?
Yes.
Are you sure you understand that? It seemed as though you hesitated.
Yes.
And is that what you wish to do?
Yes.
Has anyone promised you anything to get you to give up your right to a trial?
No.
Has anyone threatened you in any way?
No.
Are you pleading guilty because you are guilty?
No.
Why are you, well, before you answer that next question, please understand that I cannot accept your plea of guilty for any reason other than that you're guilty.
Yes.
So I ask again, are you pleading guilty because you are guilty?
No.
I'm nervous to ask, but why are you pleading guilty then?
I'm not pleading guilty.
Oh, and therein lies the question, the $1 million question. Okay.
I'm getting confused with the question.
Judge Manning, for dear, because I'm getting confused.
Okay.
Mr. Eason.
Yes.
Mr. Eason, this is Attorney Nance. Do you recall you and I had a conversation before you entered here about an offer that had been made to you by the prosecution?
Right.
Do you remember that conversation?
Yes.
And do you remember me advising you that an offer had been made and you advising that you want to tender a plea because of the license plate?
Oh, yes. It's just a question. I was getting confused. That's all it was.
I just want to make sure that we are clear, okay?
Yeah.
And
I just got confused.
The judge asked you that you are going to enter this plea because you are in fact guilty of the charge. Is that correct?
Yes.
And you are ready to move forward with entering this plea because you are in fact guilty, correct?
Yes.
Okay. Judge, I hope that helps.
Well, yeah, I guess I'm just confused as to how my question was less clear than your attorney. So I'm gonna pick up where I left off. Are you pleading guilty?
Yes.
Mr. Eason, are you pleading guilty because you are guilty?
Yes.
Has anyone threatened you in any way to get you to give up your right to a trial?
No.
Has anyone, are you doing this of your own will?
Yes.
I guess it's concerning me that he's stating that he was confused because I don't really see how the questions you asked were but so I'm a little cautious about how we're proceeding here today. But Mr. Eason, are you still there?
Yes.
Can you give me your face on video, please, sir? Thank you. Okay, so you understand that the original license documents, plates, forgery charge, the felony, is being reduced to unlawful use of a license plate, which is a 90-day misdemeanor. You understand that?
Yes.
And the expectation is in a few moments, you're going to be tendering a guilty plea to that effect. You understand that?
Yes.
And you're pleading guilty because you're guilty, correct?
Yes.
All right. You understand also that if I accept your plea, I will not be the judge that sentences you. Do you understand that?
Yes.
There will be a separate judge, a separate date for which you will appear, presumably on Zoom, for your sentencing. In between now and that date, you will have to avail yourself to a pre-sentence investigation, just essentially an interview, where someone from the probation department will ask you a number of questions. Do you understand that?
Yes.
Based on your responses, a report will be generated and provided at the time of your sentencing. And you will have an opportunity to review that, as will your attorney and the court. You understand that?
Yes.
And if there's any corrections or things you'd like to point out that are necessary, you will have an opportunity to do that. Do you understand?
Yes.
Do you understand that the sentencing judge will have discretion to sentence you as he or she deems appropriate? You understand that?
Yes.
Do you understand that if you're placed on a probation for a period of time, that at the end of that probation, this matter that you will be pleading to will not be dismissed?
Yes.
And that if you are ordered to do or fulfill certain requirements during that period of probation, if you fail to do those things, do you understand that there are further consequences that that sentencing judge can take?
Yes.
And that that sentencing judge can impose at the time of sentencing, not only probation, but a fine as well as costs. Do you understand that?
Yes.
Do you have any questions before we proceed, sir?
No.
Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Mr. Prosecutor.
As to the factual basis, thank you, Your Honor. Good morning, Mr. Esam.
Good morning.
I have a couple questions to ask you. On the date of October 16th of 2020, were you driving a vehicle in Wayne County, Detroit?
Yes.
Was that vehicle a Pontiac Grand Am?
Yes.
Did that Pontiac Grand Am display a license plate?
I didn't hear you.
Did the Pontiac Grand Am display a license plate on it?
Yes.
Did that license plate belong to a different vehicle other than the Pontiac Grand Am?
Yes.
Satisfied, Judge.
People are also satisfied.
The court is likewise satisfied that your plea is knowingly and voluntarily given. I will assign a sentencing date. What date would he have?
August 12th in front of Judge Bryant.
August 12th? And prior to that sentencing date, again, you will be contacted by the probation department for that interview. In the event that you're getting close to your sentencing date and you have not had anyone reach out to you, it's going to be important for you or your attorney to reach out to the probation department. Because keep in mind that you cannot be sentenced without that evaluation occurring. Okay?
Yes.
Is there anything further?
Not from the people.
None on behalf of Mr. Easton, Judge.
Thank you. Your plea has been accepted. Your sentencing date is August 12th, 2021, and we're all set here.
Thank you.
Thank you so
Thank you,
much.
Ms.
You're welcome.
Thank you.
Easton.
Don't leave, Mr. Slusky. Recalling Simmons, case number 2158934, the people of the state of Michigan versus Deborah Simmons. This case was previously called in full. It is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
Good morning, Your Honor. Rita White on behalf of Miss Deborah Simmons. She is not present, and I have not been able to obtain contact with her this morning.
This is a PCC, and it looks like, correct me if I'm wrong, it looks like it is the first PCC?
Correct.
So what are you asking for?
Well, Your Honor, I did have contact with her before I received discovery several weeks ago, and I attempted to contact her. And I'm respectfully requesting an adjournment to see if I can reobtain contact with her. I did check the Sheriff Connect, the jail database. She is not in jail in Wayne County. So I'm asking for an adjournment.
Okay, August 5th at 8:30 via Zoom for an adjourned PCC so that you might be able to reach your client.
Your Honor, I'll be unavailable the first weeks of August.
The first what?
2 weeks of August.
So we'll say August 19th.
Thank you, Your Honor.
Okay, thank you.
And Ms. White, I have a question for you. You said that you received discovery. Does that include any video, or did you only receive paper discovery?
Only paper.
Okay, I will check to see if any video exists. If it does, I'll forward that to you.
Thank you, thank you.
Okay, we're all set. Thank you so much.
Thank you, Your Honor.
I don't know if Mr. DiMaggio came back.
Mr. DiMaggio, are you all squared away? Are you ready for us to call the case?
Yes, I am, Your Honor.
Okay, hold on 1 second. Okay, this is a recall of People versus Curtis Scott. 2105710 and 1907815. This case was already formally called. Can I have appearances again, please?
Jacob Bloomers on behalf of the people on the case ending 7815.
And Bryn Bailey on behalf of the people in case 7107.
Thank you.
Andrew DiMaggio on both cases, Your Honor.
Okay, sir, Mr. Scott, can you please state your name, sir?
Excuse me, can I say something, Your Honor?
Say your name.
Well, right now I'm asking for your name.
Oh, okay, my name is Curtis Scott Jr. That's all. I just wanted to say something, to get a word in, but you already asked my name. Okay, I apologize for that.
Okay, Mr. DiMaggio, have you had an opportunity to speak with Mr. Scott?
Yes, I have, Your Honor.
Okay, and what's your posture at this time?
I think we're going to wait for a competency evaluation, are we, Your Honor?
Again?
Wait, say again, Mr. DiMaggio, I couldn't hear you.
I thought that Ms. Shabazz said that he was interviewed on Tuesday of this week. Is that correct?
Wait, are you talking to, okay, so I guess I just want to know, now that you've had an opportunity to speak with Mr. Scott, what is your posture?
My posture is, firstly, I get the documentation. I don't have anything really to go by. I need more discovery in that.
Okay. And I'm assuming, I'm just allowing you an opportunity to put some verbiage on the record, but are you asking for us to adjourn this because we're still waiting on the evaluation?
Yes, that was I said that initially, Your Honor.
I will have to say, I can't hear the words coming out of your mouth. I hear noise, but it's very muffled.
Okay. Yeah, what I was trying to say is I was going to wait to have this case adjourned until the evaluation comes in, Your Honor.
Okay, so the unknown that we're dealing with is when that evaluation will be here. According to Ms. Shabazz, after having spoken with, I believe, the deputy, it was confirmed that Mr. Scott was interviewed last week or this past week. So that, I would imagine, there's not going to be a report that's going to come right around the corner. I don't want to adjourn it another 90 days, but perhaps 30 or 45 days. Where would that put us, Madam Clerk?
To August 27th.
August 27th at 8:30 via Zoom. Just hopefully that would be enough time for a report to be generated. He said August 27th.
Yes.
Are you available then, Mr. DiMaggio?
Yes, I am, Your Honor.
Okay, Mr. Scott, what did you want to say, sir?
Excuse me, what's your name, Your Honor?
Pardon?
Can I get your name?
Wait, say, I'm sorry, can you say what you're asking for Mr. DiMaggio's name?
I want his name as well. DiMaggio and the judge name on the case and just.
Mr. DiMaggio, can you furnish him with paperwork regarding all the players as it relates to this matter? You're in Judge Archer's courtroom, but I'm assuming Mr. DiMaggio is going to receive the discovery from Mr. Bloomers and Ms. Bailey, and Mr. DiMaggio is going to supply you with any and all the information that you're seeking. Mr. DiMaggio, is that true? Can I make that assertion?
That's correct, Your Honor.
Okay, is there anything else you want to add to the record, Mr. DiMaggio?
Not at this point.
Mr. Bloomers?
Just briefly, I just want to say I just sent a link to Mr. DiMaggio from evidence.com that has the paper and digital discovery on the DV case, so he should get that sometime today.
Ms. Bailey?
I have also done the same on the home invasion case.
Okay, is there anything further?
Nothing from the judge.
Okay, we'll see you August 27th at 8:30 via Zoom.
Thank you, Your Honor.
Are we ready on Trent?
If people are ready, Your Honor, although I believe that Ms. Jefferson is having a conversation with her client.
And Judge, Jane Steen, Misty Coleman, she is.
Yeah.
Can you let me know if a Mr. Steen has checked in or when he does?
He has not checked in just yet, but I'll let you know as soon as he gets here.
Okay, thank you.
No problem.
Sanders is away. Anyone check in on Smith? Tion Smith?
Your Honor, I don't suppose we could call that case. As I understand, the defense is going to request an adjournment. Based on my conversation with him, I believe Mr. Smith is on his way. But if we could address the adjournment, then.
Is the attorney here?
Yes.
Oh, okay. Sorry. Are you taking Mr. Snyder's place?
Yes, actually, well, probably most, if not all of Mr. Schneider's cases have been reassigned to me.
Okay. Calling parties on Smith. Case number 2060916. The people of the state of Michigan versus Tion Markel Smith Jr. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. Count 2, driving reckless, commission of a felony with a motor vehicle advisory. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
Good morning, Your Honor. Neighborhood Defender Service by Andrew Sullivan, P84261. As I was just explaining to the clerk, the prior attorney, Mr. Henry Schneider, is no longer with our office, and so I'll be handling this case through to resolution.
Thank you. With today being an examination date, are we proceeding to an exam? I noticed Mr. Tion Smith is not here.
Yes, Your Honor. I've had good communication with Mr. Smith. We spoke on the phone yesterday. We've been texting this morning. He is running a little behind at 10:27. He told me he's 20 minutes away. I spoke with the state about the case earlier this morning. My request for an adjournment today is based on the fact that although I have paper discovery and have been able to review that, I do not have digital discovery. The police report explicitly mentions that there is dash camera video as well as a video recorded of my client making a statement. I understand that the state has a disc with those videos on their person today, but I just haven't had an opportunity to review that, so I'd be requesting some time to do so.
Well, that certainly sounds to me like good cause to request and grant a new exam date. Did you care to be heard, Mr. Slesky?
Yes, Your Honor, this is the second exam that we've had scheduled. It's the second date that my witnesses have been available. My notes indicate that.
Can you call your witnesses in?
Yes. Okay. Yeah, thank you. What occurred previously, as Mr. Sullivan stated, there was a previous defense attorney on the case. My notes indicate that I sent complete discovery to the previous defense attorney. I was emailed yesterday, I believe, by Mr. Sullivan indicating that he did not have any video. I looked through my records, and again, I had a note that was sent to Mr. Schneider, but I wasn't able to locate the video myself on my computer. I emailed the OIC yesterday and received discs of that I can provide to the defense today. Unfortunately, the discs I can't. I regret I wasn't able to also get that to him yesterday, but considering the previous time this case was up, that we've been prepared to proceed twice now and have not, the people are prepared to proceed and would request the support the permission to proceed on this case.
Thank you. So I'm assuming that's an objection to the request that's being made, and that objection is noted, but what counsel has indicated is good cause. He's the new defense attorney stepping into this case from Mr. Schneider. I'm not going to force him to proceed on a matter that he has not had an opportunity to fully review the discovery, particularly the digital discovery. So I'm going to grant, particularly also considering that your client is not in custody. It's not a perfect world that you've got your troopers behind you and they've been here, but this unfortunately is the nature of court. And I'm not going to ever put an attorney, whether it's the prosecution or defense, in a position where they're proceeding and they have not had an opportunity, given the procedural history with this case, to intelligently represent their client. So with that being said, I do find good cause to grant the request for an adjournment, and I wanted the officers in here so that we can make sure that the new date is not going to conflict with any furlough or any other training, etc. This is a non-custodial case, and due to the nature of the allegations, it will not be around the corner, so there'll be plenty of time to remedy any digital discovery issues. Madam Clerk?
Judge, November 1st at 11 a.m.
Hearing no issues.
That works for the people, Your Honor.
Okay, November 1st, Mr. Defense?
That works for the defense as well. Thank you.
November 1st at 11, did you say 11?
Yes.
11 a.m. will be the new in-person examination date. And I'm not really sure where Mr. Tion Smith is, but I take your word as an officer of the court that he is in transit and he's.
Yes, Your Honor. As I said, I have had conversations with him yesterday. He was prepared to be here. He is just running late. He has texted me that he could be here in 3 minutes if you want.
Okay. Well, I will waive his presence for purposes of this request that's being made. If, however, he does pop in when you're leaving out, if you could have him just show his face.
Of course.
And we're all set. Thank you.
Thank you, Your
very
Honor.
much, Your Honor.
You're welcome.
Are we ready on Trent? Judge, I'm not sure that who that is. They've been there all morning.
Mr. iPhone user, what's your name?
You never really check.
Mark Brown.
What is it, sir?
Mark Brown.
Jamar Brown,
Yes, ma'am.
your attorney appeared on your behalf and your next probable cause date is August 5th. Mr. Moxie will be contacting you.
Okay, thank you.
You're welcome.
It's going on 11 and I don't feel any cooler. Oh, good morning, Ms. Kraus.
Good morning. Don't blame you guys for shutting down. I just got back from there.
You look a little shiny.
A little bit.
As soon as Miss Bailey comes back in here, we'll call your case. I don't know if we need to have that gentleman brought up.
Oh, yeah, is he here? Is Mr.
Mr. Pitts is here.
Pitts here?
You need them brought up?
Yeah, because we're gonna adjourn it.
Sure.
I didn't even get my case, stuff entered from yesterday. Now I'm not getting stuff from today entered either. And I still have cases to adjourn.
You said Mr. Pitts?
Yeah, I believe that's who's downstairs.
Yes.
Yes, the office.
Judge, good morning.
Mr. Pitts is on his way.
Yeah, I'll call it as soon as, your client gets up here, Mr. Brown. Are we ready to call Trent?
Thank you very much.
Yes.
Calling parties on Trent, case number 2059329. People of the state of Michigan versus Justin Francis Trent. The defendant is charged with count 1, controlled substance, delivery, manufacture, 5 to 45 kilograms of marijuana synthetic equivalent, or 20 to 200 plants. Count 2, controlled substance, delivery, manufacture, marijuana synthetic equivalents. This matter is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Thomas C. Jefferson on behalf of Justin Trent, P4872. Mr. Trent, take your name for the record.
Justin Trent.
Thank you. Okay, today is the date and time set for preliminary examination. Are we proceeding to an exam?
No, Your Honor, at this point, we're gonna waive the exam.
Is there any objection to the proposed waiver?
No, ma'am.
Okay, Mr. Trent, do you understand the allegations against you, sir?
Yes.
And do you understand that you have a right to a preliminary examination?
Yes.
Do you make sure your answers are audible for Madam Court Reporter, okay? Do you understand that if an examination did occur, that the prosecutor would need to establish by a probable cause standard only that crimes were committed in the city of Detroit County of Wayne, that you probably committed those crimes? Do you understand that?
Yes.
And if the prosecutor were able to meet that burden, the matter would then be bound over to circuit court. Do you understand that process, sir?
Yes.
So the representation has been made by your attorney, Ms. Jefferson, that you wish to waive, to give up your right to preliminary examination. Is that true, sir?
Yes.
Do you understand that that means that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an exam at this phase?
Yes.
And again, is that what you wish to do?
Yes.
And are you doing so voluntarily?
Yes.
That being said, I do need an examination waiver form that's going to need to be filled out with both Ms. Jefferson with your signature as well as your clients. I do find the waiver to be knowingly and voluntarily given. The matter will be bound over to the circuit court for further proceedings with an AOI date of July 29th. Is this your case, Trooper?
Yes, ma'am.
Thank you. Anything further?
No, Your Honor.
Nothing further from the people.
All right, I just need signatures and we're all set.
Here you go.
July 29th.
Yes.
Mr. Pitts is in there.
Oh, thank you so much.
Let me bring him out.
He's in one moment.
Not just yet, yeah.
Officer Long?
Good, Your Honor.
Good, how are you?
Good.
It's hot, huh? It's hot. I mean, it's hot. Caliente.
Mr. Pitts, is she on, Judge?
Ms. Kraus?
There she is. She was standing in front of the air conditioner. Yeah.
The air isn't working in my office either, so I'm getting doubly.
Mr. Brown looks very comfortable though.
Yeah. It looks like he's got air.
I am, but I can hear now. I couldn't hear before, so I'm good. I can hear you and I'm
Yeah, we
comfortable.
were calling parties on Kimbrough and Pitts, case number 2156809. People of the state of Michigan versus defendant number 1, Shatanya Unique Kimbrough. The defendant is charged with count 1, police officer fleeing third-degree vehicle code.
That was it.
That's it. Defendant number 2, Trent Leonard Pitts Jr. is charged with count 2 and 3, assault with intent to murder, count 4 and 5, assault with intent to do great bodily harm less than murder or by strangulation, count 6, weapons, firearms, discharge from vehicle, count 7 and 8, assault with a dangerous weapon, felonious assault, count 9, 10, 11, 12, 13, 14, and 15, weapons, felony, firearm, count 16, weapons, felony, firearm. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Sarah Kraus, P81830, standing in for the attorney of record, Gabby Silver, for Ms. Kimbrough. I'm asking that her presence be waived for purposes of this hearing.
So ordered.
Good morning, Your Honor. May it please the court. Mark Brown, my P number is 39562, appearing on behalf of Mr. Pitts. Judge, I'll wait.
Mr. Pitts, can you state your name, please, sir?
Trent Pitts.
Thank you. So we're here today. I'm asking both prosecution and defense to zoom in advance of the 1:30 exam time, due to the fact that we just received a memo that the courthouse is going to be shut down at 12 because of the power issues that are that have not been resolved. So that unfortunately, is going to affect our 1:30 examination that we had set. We need to select a new date, and I don't know what sort of magic Madam Clerk can come up with, but I'm gonna ask her to. One defendant, Mr. Pitts, is in custody, Ms. Kimbrough is not, so we certainly are sensitive to the fact that Mr. Pitts is in custody.
Judge, may I interrupt?
Yes.
Okay. Last time we were here, I don't know if is it Miss Bailey who was the prosecutor?
Yes.
Okay, I'm not familiar with her, but I had discussions with Ms. Yafufi, who, and also the officer in charge, Mr. Jamar McIntyre. And I'm not sure, Ms. Bailey, are you familiar with those discussions about the case and about Mr. Pitt's position in the case?
To an extent, I am.
Okay, so last time, this is out. I think it's important because Mr. Pitts has been here. The case has been adjourned enough times for different reasons, but he is in custody, and I'd like to address the bond, which might affect the date. It's my understanding that there is a ongoing review with supervisors about amending the charges to lower charges. Is that correct, Ms. Bailey?
That has not been explored at this time. However, it is my intention that after court today, that my supervisors and myself will go through the case with a much finer tooth comb again.
So you have
no discussions with myself have been made at this time.
No, I'm not talking about with you, but are you aware of discussions? I guess, see, I'm caught here because I got two different prosecutors. I've spoken to Mr. Fufi, and I've spoken to the officer in charge of the case. So it's my understanding that they're reviewing the case to reduce the charges, and you're not aware of that.
I am informed that that is Ms. Yafufi's intention to do. It has not been done as of yet.
No, I'm not saying it's Mr. Yafufi's intention. Mr. Yafufi can't do it. It has to be done by your supervisors. I think that's where
that discussion hasn't taken place yet.
Okay. All right. Well, whatever is happening, Judge, I'd like to request a reduction in his bond. This is it's a serious matter, but there are serious conversations ongoing within the prosecutor's office with the officer in charge, Mr. Detective McIntyre, who I'm informed to believe was present but was not allowed into the court earlier this morning. Excuse me. And so, if there's any way possible you could address his bond and reduce the bond, I would certainly ask you to do that. He is, as I said, been sitting in jail for quite some time. I think the original exam date was sometime either in May or early June. So.
Well, I don't have a DSU report here to refer to for any background information. And you obviously know way more about the nuances of this case that might prompt the prosecution to investigate or reanalyze this matter to determine whether it was properly charged in the first place. But at this juncture, I have nothing before me that would indicate that the bond should be reduced, other than the fact that there have been delays, and those delays have not been arbitrarily occurring. I see that the charges against your client are extremely serious. And I'm trying to look at the document here to understand even what his bond currently is. Do you know? Oh, $500,000 cash or surety with no 10%. And obviously no contact with the witnesses here. And a GPS tether and no weapons. Madam Prosecutor, so it sounds like there is an attempt to at least determine whether or not there should be some reconfiguration of the allegations in this complaint. What is your posture on the motion that has been made to reduce the bond?
Your Honor, people would be amenable to a 10% provision to be added. Should the court deem anything else appropriate, the people have no further position aside from a 10% provision in appropriate.
Okay, again, without any further information being tendered that would warrant a deviation, I will say that given the representation that the prosecutor has just made, I have no problem with adding a 10% provision to the $500,000, as the prosecution does not object. But anything beyond that, I am not comfortable with doing at this time because I just don't have any other information before the court. We need to select a new date, Madam Clerk. Oh, and Mr. Mark Brown, do I have permission to sign your name to the motion to reduce bond?
Certainly, Judge, you have my permission to sign my name, reduce it further, whatever you want to do is fine with me.
Okay, thank you.
I don't know. I'm just gonna change this case again. I have an out of custody case, but it's once the guy filed the motion on, and then I changed it, and then I changed it again, because it was actually scheduled for today. But it's out of custody, so we can put this
Yeah,
in.
it's gotta move.
There's really nothing else I can
Yeah,
do.
it's gotta move. If it's non-custody, it's gotta move.
So
I hate to do it,
then
but
we
it
can
does.
do July 30th at 1:30.
July 30th.
The best I can do.
That works for me.
I hope it works for you, Mr. Brown, because that's the only thing we've got until the third week in August.
Well, given those representations, I guess I'll take July 30th. That's fine, Judge.
Okay, July 30th at 1:30, it's 1:30, right?
Yes.
At 1:30 and for both Kimbrough and Pitts. I will make sure that I'm signing this motion to reduce bond. That's going to be forwarded to you, Ms. Brown.
Thank you. And Judge, may I ask that because we're in the circumstances we are now, that there be a DSU report, our investigation conducted in the event that we have issues at the next time we're here. So
Absolutely.
thank you.
Okay, is there anything further?
Nothing further from the people.
No, Your
Honor.
In the event that there is any sort of adjustment to the complaint with, I'm assuming there would be a first amendment that would be provided to Mr. Brown and perhaps even to Ms. Kraus as it relates to Ms. Kimbrough. I don't know if the possibility of any change would affect Ms. Kimbrough or not, but please make sure, Madam Prosecutor, if either yourself or Ms. Yahubi becomes aware of any changes, that both defense attorneys are made aware of that in advance of the exam date.
Yes, ma'am.
Thank you.
Thank you, Judge.
Thank you.
You're welcome.
Okay, so we still have a few matters here. Are we ready on Steam? Did anyone check in on that, on Steam?
No one's checked in on Steam just yet.
Okay.
We can still call it.
Even if he's not here?
That's fine. I'm going to dismiss.
I haven't yet. Give me a second. Oh my gosh. I think my brain is shutting down. I went to ask, I'll ask Mr. John. That's it, Mark's, his attorney's on the phone. No, I'm not going to. What are we doing on Elliot?
What I understand, Elliot, Mr. Elliott is a failure to work here. He's not here.
Would you mind standing in for a dismissal for me for Ms. TFO?
I have no problem with that.
Thank you so much. I'm gonna call that right now.
Absolutely.
Calling parties on Steen, case number 2058024. The people of the state of Michigan versus James Lee Steen III. The defendant is charged with count. I'm not sure what count one is. Count one, police officer fleeing, fourth degree vehicle code. Count two, police officer assaulting, resisting, obstructing. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Respectfully, Your Honor, Sam Janella, P62186, standing in for the attorney of record in this matter.
Thank you so much for doing so. I
Absolutely.
appreciate that. Today is the date and time set for a preliminary examination. Madam Prosecutor.
Thank you, Your Honor. The people are unprepared to proceed today. I found out recently that the necessary officer is on military leave. However, the reason
So, whatever happened to Sykes?
No. Your Honor, at this time, I believe we're prepared to proceed. However, I was informed by, Mr. I can say Ludovic.
Ms. Bailey, hold 1 second, I'm sorry.
Yes.
Is Mr. Dox here?
They're both here.
All right.
Mr. Sykes and
All
Mr.
right, let's
Wait,
bring.
hold on.
Oh, yeah, okay.
Yeah. Case number 2059023, the people of the state of Michigan versus Jovan Claybron. The defendant is charged with count 1, prison, cell phone violations, habitual offender for defense notice. The defendant is also charged in case number 2055159, people of the state of Michigan versus Jovan Claybron. The defendant is charged with count 1, prisons, prisoner possessed contraband. Count 2, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Habitual offender, third offense notice. These matters are scheduled for preliminary exam.
Thank you. All right, so, can I have appearances, please?
Good morning, Your Honor. Brenda Bailey on behalf of the people, P84009.
And your name, sir?
Jovan Claybron, info party.
Thank you. All right, so, before I pivot to the prosecution, and the defense to ask if there's any preliminary matters, the court has preliminary matters. It's going to take quite a while for me to get through, but it's necessary each and every time you come before the court as someone who is acting pro se. It is currently, what time is it, 11? It is currently 11:36, and you may or may not know, but the court is being shut down at 12 because of, as you can probably tell, it's there's no air. And we're having power issues because of the weather. But that being said, I'm gonna proceed anyways, as far as we can. Again, at 12 o'clock, we don't have discretion. The courthouse, entire courthouse shut down. And we just received that memo shortly, not long ago. So, Mr. Claybron, the charge has been read off, but I'm gonna read it off again. You are charged in the first file, which is the first file that I'm gonna stick with because that's the one we're proceeding with first. Each exam would be called and presented separately. So let's start with 200590023. You're charged with count 1, prisons, cell phone violations. That is a felony wherein there's a maximum of 5-year penalty and or $1,000. Cell phone violations, including the language that did being a prisoner in a correctional facility, did possess or use a cellular telephone or other wireless communication device in or on the grounds of the correctional facility without authorization. You're also listed on this file as an habitual offender with fourth offense notice. So, you have indicated on the record that you are in pro per. And so I ask first, again, do you wish to represent yourself? And please understand all of these questions, I pretty much know the answers to. This is more for creating a record than it is for anything else because I know that we've gone through these ad nauseum, but I am compelled and required to go through this each and every time. So again, your representation is that you do wish to represent yourself.
Yes, sir.
You have to make sure that your answers are audible because they're all being recorded. I ask again, do you wish to represent yourself?
Yes, sir.
Okay, and with that being said, you do not want counsel to either advise you or even to be in an advisory capacity behind you?
No, you don't.
And you understand that the allegation against you in this one file alone is very serious. Again, a felony with a mandatory, a maximum penalty of 5 years and or $1,000?
Yes, sir.
And you understand that if you do proceed by representing yourself, that you would be held to the same exact standard as an attorney who has gone to law school and is apprised of all of the regulations and rules as it relates to the court.
Yes, sir.
And you understand that if you are unable to proceed in a manner that you feel is appropriate, if you're not abiding by the court rules, you cannot get very far, and you understand that the potential pitfall to that would be that you are facing a situation where you are looking at a maximum penalty of 5 years and or $1,000.
Yes, sir.
And you understand that that is a bell that you can't unring. Once you start this process, there is no deference that, okay, this young man is representing himself and he should be granted certain latitude. You know, that will not exist once that is waived.
Yes, sir.
And so you understand that that self-representation, that risk of self-representation is potentially going to create a situation where you may not know what the answer may be for certain things, and the court cannot assist you in that regard. You understand that?
Yes, Your Honor.
And you understand that you are afforded an opportunity to have an attorney. You have a right to an attorney, and if you couldn't afford one, one would be appointed to you. You understand that?
Yes, Your Honor.
And you knowingly wish to waive representation or even to have an attorney present?
Yes, Your Honor.
And you do not wish at this time to consult with an attorney in any form prior to proceeding with this examination and self-representing?
No, Your Honor.
Okay. And again, you do, let me just indicate that every matter that every single one, there hasn't been one, not one. And the 15 years I've been on the bench where an individual who has decided to represent themselves, there has not been a situation where they haven't gone out one door or the other, extremely upset and frustrated because they think that because they're most familiar with the case, that they can represent themselves. And then they understand, as the matter proceeds, that there are certain things that they will not have deference in being able to do because they don't have a license. That's my experience, and I'm just putting that out here. I think I've said this each and every time you've been on, but I say it again because I have to protect this record. Do you understand that, sir?
Yes, Your Honor.
And you wish to proceed even in light of the potential harm that it may possibly present to you?
Yes, Your Honor.
Okay, with that being said, I find your waiver to be unequivocal at this time. And with that being said, we are going to start this examination again at 12 o'clock. The record stops really at 11:59 because we need at least a minute to get out of this courtroom. Are there any preliminary matters before we begin?
None for the people.
Yes, I have a small issue with the discovery that the prosecutor had sent me. It was missing some key items that I need for her to please explain to me and you, according to the court rules. MCR 6.201, it says she must hand over all exculpatory evidence. There was no affidavit and no warrant with this discovery. And I think I have a constitutional right to know what judge signed the warrant for my arrest and what they used as probable cause according to the court rules.
Is this the motion that was heard?
Yes, Your Honor.
No, this is not, because she just sent me discovery. So this is not the motion that was heard. I've never filed a motion on a Brady violation, never, because I didn't have all the discovery. So now that I've received discovery, I would like to file a motion for a Brady violation because these items, are according to the court rules, must be provided to the defendant.
Okay.
Any affidavit.
All right. You will have, let's see, today's the 8th, you'll have by the 22nd to file that motion. I need it, whether it's in writing or not, it needs to be provided to the court, it needs to be provided to the prosecution. And prosecution, I need you to respond to that by August 5th. We are gonna set a hearing in this matter for that following week. So what would that be? August 12th. August 12th at 8:30 via Zoom is going to be the motion that counsel, Mr. Claiborne indicates he's going to be filing. It has to be timely. Motion has to be filed timely, it has to be in writing. That's, it has to be in writing, right? It has to be in writing, and then the court reviews it, and the prosecution has to respond to it in writing, right? Right, because that's what we do, right?
Yes, yes.
And then the court is going to hear the motion on August 19th. Or no, I'm sorry, August 12th.
Your Honor, just to respond on the record, if this is to be a Brady motion, that is an improper motion to be heard at the district court level. Additionally, discovery is ongoing, and I've provided Mr. Claiborne with everything that I have at this time, and I would just reiterate that a Brady violation motion at this level is inappropriate according to.
I don't know what he plans to file. Okay, so if you want an opportunity to make a motion, the court is granting you that opportunity. You must file that, I'm not gonna repeat myself. So is there anything further?
No, Your Honor.
Okay,
I just
thank you.
wanted to make a record.
Yes, there is one other issue, Your Honor. Because under.
You have to speak up louder, sir.
Oh, under People versus, Franks versus Delaware, and People versus Franklin, I'm also entitled, or asserting my constitutional right.
You have to file a motion.
Okay, yeah, but I'm telling the warrant's veracity because she
You
said,
know what?
she said in her motion that was before that she provided the judge with probable cause.
You
with
need
the
to
complaint
file
and
a
warrant.
motion laying out what you're concerned with. The court receives it, the court reads it, the court reviews it. In the meantime, the prosecution responds saying, A, this isn't relevant. B, whatever they want to say, whatever the case is, this is the process. You can state what you'd like to state on the record, but any motion needs to be filed.
But the last time I filed a motion.
You have to speak up louder, sir. I don't even know if she can hear you.
The last time I filed a motion, you said y'all didn't get it. That was 3 months. So how am I supposed, what do you want me to do to make sure it gets to y'all?
You're going to have to ask the deputy, there's no mouthpiece that's speaking for you, so I don't know who is the liaison, but perhaps you need to ask the deputy, maybe Deputy Smith, who was the one who helped you before, can help email whatever you've got, or screenshot, or scan to the prosecution and to the court. Unfortunately, I don't unzip my robe, go to the jail, and play a role in the delivery or the acceptance. So July 22nd, that is the deadline for the filing. August 5th is the deadline for the response. The hearing is going to be August 12th at 8:30 via Zoom. Thank you so much. Thank you so much. We're all set.
Yes, ma'am. Come this way, sir.
Mr. Doc's here yet?
He's somewhere out there, man. I can't track him down as of right now. Have a seat.
I'll go check. He is not available, Your Honor. Not out there.
Pardon?
Mr. Doc, Attorney Doc is not out there.
Not out there? Okay, well, then,
His client is here.
I know you've already probably tried to call him, Tanner.
I'm trying to read something.
Were there witnesses on the Mr. Doc's case?
Yes, Your Honor, we had all witnesses.
Is there an attorney in the hallway that can maybe stand in for an adjournment? Perhaps, I mean, with weather and everything else, perhaps Mr. Doc's has had an emergency. He's not responding to calls.
I will go see Your Honor.
Mr. Dox, this is Tammy from Judge. We need you in here. We're shutting down at 12 o'clock.
Wait, Miss Bailey, I think we have some, or maybe can you put him on?
I'm sorry, can
Speakerphone?
I put you on speakerphone? You're not gonna be
Can I
able to
trouble you
hold
to
because
get
the
her,
court is
the young
shutting
lady?
down at 12.
Sykes in here?
Yes.
I'm gonna put you on
Yes, ma'am.
speakerphone. Okay, Judge.
Good morning, Mr. Doc's.
Good morning, hi. I was with the hold, Your Honor.
This morning?
Good morning.
Wait,
Yes,
so why aren't you here?
I was, Your Honor. I checked in and I I was here to talk to my client. I was out here early.
We're gonna call the case, but I don't know if you've gotten a memo, but the court's shutting down, so. We're calling your client into the courtroom. And if you were here, nobody has seen you or anything like that, so we've been in here constantly working, just so you know. But we're gonna call the case, right now and put it all on the record. Thank you so much.
Calling parties on sites, case number 2057555, the people of the state of Michigan versus Ebony Burnell Sites. The defendant is charged with count 1, breaking and entering a building with intent, habitual offender, fourth offense notice. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Morning, Your Honor, Bryn Bailey on behalf of the people, P4009.
Mr. Dox? Mr. Dox?
Oh.
Are you there, Mr. Dox? Mr. Dox? Oh.
Good morning, Your Honor. Attorney Quinn Dox, P number 79657, on behalf of my client, Mr. Ebony Sykes.
Thank you. State your name, sir.
Ebony Burnell Sykes.
Okay, let me first state that this is an examination that's in person. The court was prepared to hold. Every time we called for counsel, no one seemed to think you had checked in. And I'm sure you have. I don't doubt that. I'm just letting you know what's been going on, and we have been constantly on the record. There hasn't been a break where we were saying, oh, I wonder where he is, and I guess we just won't do things today. Your client is not in custody. We've had in custody matters that we've been dealing with, which are the priority per the directive from the Supreme Court. So with that being said, also coupled with the fact that the court is shutting down in 8 minutes for obvious reasons, but the record should reflect we're having power issues. And there is no air amongst other issues that are apparently going on. So we are unable to hold this exam in 8 minutes. We do need to find an alternate date unless your client's intention was to waive. It is my understanding witnesses are here.
We have an alternate date, that's fine, Your Honor.
Okay, Madam Clerk? Given the nature of the allegations, it's not unfortunately gonna be right around the corner.
Mr. Dox.
Judge, October 5th at 11 a.m.
Works for me, Your Honor.
Okay, October 5th at 11 a.m. in-person exam.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Sorry for the confusion. You were in probably in a witness room?
I was using the bathroom, Your Honor.
Oh, okay, all right.
Oh, there's attorney on Hilton?
Yeah, we'll get you some. So late.
Calling parties on Hilton, case number 2155812, the people of the state of Michigan versus Michael Hilton. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle, habitual offender, fourth offense notice. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
Good morning, Judge Lauren Anderson, on behalf of Mr. Hilton, the number is 85191, and Mr. Hilton is currently incarcerated in Tuscaloosa County.
Wait, say that part one more time?
Mr. Hilton is incarcerated in Tuscaloosa County and is not present.
Oh, I didn't know that.
Your Honor, if I could illustrate what happened here in this case.
Okay.
Previous defense attorney that appeared on this case was Blaze Kearney. At the previous PCC, Mr. Hilton was released on a tether. The case out in the other county, I believe, is carjacking, and our case is receiving and concealing that same vehicle. I don't really know why he was released on tether for that other case, but with that said, he was not in custody when we had this scheduled. As I understand, Ms. Anderson attempted to contact me about that. She emailed me, but she sent it to an email ending in .org. So I never received that email. which mine ends in .com, so honest mistake to make, but I wasn't aware that Mr. Hilton was in fact picked up for something arising out of that other case. That I would have to assume would be some new development that the court didn't have at the prior PCC, because as far as we know, as far as Mr. Kearney knew at the time, he was released and we kept this as a not in custody.
What was the last thing you said?
We had Mr. Hilton as being not in custody, so
Okay.
I was not aware that he was picked up. I did not perform a writ because as I last understood, he was not in custody and a writ would not be required. Now, as I understand, he is in custody, a writ would be required to bring him down, and there are a few trial dates, so hopefully we can schedule around that. And Ms. Anderson, would you agree with my interpretation?
Absolutely, Judge, I agree. Okay, so with that being said, we do need to select a new in-person examination date. Which would, how much time do you need to process a writ?
A writ requires a minimum of 10 days.
Okay,
So with,
we're looking at the week of the 26th, if you want to pick a date.
Judge, I will be in your courtroom that Wednesday, the 28th. I have a prelim at 11:30 that day.
Can we do it then? Okay.
Yeah, I guess.
I know.
I mean, it's just all running together. But he is in custody, so something else has to get moved.
Okay, July 28th at, what time you said you were going to be here?
I have an 11:30, but it's my only one that day, so I can work around you.
Okay, can we say 11?
Yes, ma'am.
Your Honor, I do want to let you know I have another case at 11.
In here?
It's across the hall. I'll be here, but I do have another case scheduled at that time. I can do my best to make it work.
Well, let's set this for 10:30 then.
Okay.
Thank you.
All right. Okay, the court is going to, are we done?
Yeah, that's it, Judge.
The court is going to shut down according to the memo. The courthouse is shutting down at 12 noon, which is 3 minutes from now for power issues that the courthouse is having.
Thank you.